Welcome back to the Deep Dive. Today, we are opening up a stack of research that feels, incredibly familiar on the surface. But the deeper you go, the more you realize that the popular image, it might actually be hiding the real story. We are talking about a figure who became a legitimate pop culture icon in her 80s. We're talking about the Notorious R.B.G.
Ruth Bader Ginsburg.
Exactly. And I think for most people listening, when they hear that name, a very specific image pops into their head. It's the memes, right?
Oh.
It's the notorious crown on her head, the tattoos people got, the coffee mugs with the dissenter collar. It's this tiny elderly Jewish grandmother figure who somehow became this internet action hero.
Which is a fascinating cultural phenomenon in itself, of course, but if we aren't careful, the meme can obscure the reality of who she actually was and what she actually accomplished.
Totally. I mean, did you know there is a species of praying mantis named after her? The Ilomantis ginsburgi.
I did see that in the notes, yeah. It's a very specific kind of biological tribute.
It's incredible. Scientists named it that because the neck plate on the mantis resembled her famous bouts, those lace collars she wore over her judicial robes.
Ah, I see the connection.
And get this, they identified this new species based on the female genitalia instead of the male, which is apparently very rare in entomology.
It was a deliberate nod to her fight for gender equality.
Okay, that is actually quite fitting. But you're right, that's the pop culture layer. You have the mantis, you have the Saturday Night Live sketches with Kate McKinnon doing the Ginsburgs.
Classes.
You have all the merchandise. But the mission of this deep dive is to peel all of that back. Because long before she was a meme, she was a strategic legal architect who fundamentally, and I mean fundamentally, changed the way American law understands gender.
And that's the part I really want to unpack today, because I think people see the I dissent collar and they just assume she was always this firebrand, shouting from the rooftops.
Right, a revolution. But looking at the source material, at the case files and the biography, her actual career path was different. It was calculated. It was slow.
It was incremental. And that's a key theme we need to explore today. We're going to be looking at her biography, her career summaries, specific case files, both dissents and majority opinions.
Right.
And we're going to move past the icon to understand the work. We'll look at her origins, that incremental legal strategy, the specific cases where she redefined discrimination, and, crucially, the complexity of her views.
Because she wasn't always the liberal icon people imagined.
Not at all. She had some very pointed critiques of Roe v. Wade, for instance. She had a complex record on Native American rights. She was a deeply nuanced jurist.
And a resilient human being. The health battles alone are just staggering.
Absolutely.
So let's get into it. Let's go back to Brooklyn. Before she was RBG, she was just Joan.
Joan Ruth Bader, born in 1933 in Flatbush, a working-class Jewish neighborhood in Brooklyn.
But the family didn't call her Joan. Apparently, there were too many Joans in her kindergarten class. They called her Kiki.
A nickname her older sister, Marilyn, gave her because she was a kicky baby. She was active, restless from the very beginning.
I love that. But her early life wasn't just, cute nicknames and kicky baby stories. It was marked by pretty severe tragedy, wasn't it?
It was, and this is really essential to understanding her drive. She lost her older sister Marilyn to meningitis when Ruth was just a toddler, about 14 months old.
Wow.
So that made Ruth effectively an only child, carrying the full weight of her parents' hopes and dreams. And then her mother, Celia, who was the absolute driving force behind her education, battled cancer throughout Ruth's entire high school experience.
And the timing of her mother's death is just... It's just heartbreaking.
It's awful. It happened the day before Ruth's high school graduation.
The day before.
So she didn't attend the ceremony. She stayed home to grieve. But her mother left this indelible mark on her psyche. Celia had been a brilliant student herself, graduated high school at 15, but her family sent her brother to college instead of her.
That was the classic story of that era.
Yeah.
The resources, the opportunities, they all went to the sons because they were the ones expected to be the providers.
Precisely. So Celia was determined that Ruth would have the opportunity she was denied. She constantly pushed her to be independent. Be a lady, she'd say, but be independent, and she pushed her to read.
And there's this layer of Jewish identity here that seems really interesting and foundational to her worldview.
Yes. The Baders weren't devoutly religious in terms of ritual. They weren't keeping kosher in a strict sense. But the cultural influence was profound.
I read about the concept of tikkun olam in the files. Can you explain that?
It means repairing the world. It's a central tenet of modern Jewish thought. The idea is that the world is broken or incomplete, and it is a human duty to participate in fixing it, to pursue justice. That influenced her deeply.
But she also felt the sting of exclusion within her own faith, right?
She did. As a teenager, she wasn't allowed to have a bat mitzvah because of Orthodox restrictions on women reading from the Torah or being part of a minyan, the quorum for prayer.
Which feels like the first brick in the wall of things Ruth is going to dismantle later. Even in the space that gave her this powerful moral instruction, she was being told she was secondary.
Exactly. It's a foundational experience of being an outsider. And much later in life, she kept a framed artwork in her Supreme Court chambers with the Hebrew phrase Zedek, Tirdoff.
Which means?
Justice, justice shall you pursue. It comes from Deuteronomy. It was a constant reminder of her heritage and her professional responsibility. For her, law wasn't just a job, it was a calling, and it was rooted in that early identity.
So she heads off to Cornell University, where she meets two very important men who shape her future in very different ways. One was a world-famous novelist, and one was a tax attorney.
The novelist was Vladimir Nabokov.
The guy who wrote Lolita, he was her professor.
The very same. She studied European literature under him. And this is a really key takeaway for anyone who reads her legal opinions later. Nabokov taught her that words are precision instruments.
How so?
He hated vague language. He taught that the placement of a single word, a comma, changes the reality that a sentence describes. You can see that so clearly in her legal writing. It is dry, it is incredibly precise, and there is zero fluff. It's all about clarity and impact.
And the tax attorney.
That was Martin Ginsburg. Marty. She met him when she was just 17, and she famously said he was the first boy she ever met who cared that she had a brain.
Marty sounds like a character.
Oh, he was. By all accounts, he was the opposite of her in almost every way. He was outgoing, funny, the life of the party, a bit of a class clown. Ruth was shy, serious, incredibly intense.
And they got married right after she graduated from Cornell.
They did, but then they head to Harvard Law School in 1956, and the reality of the 1950s it hits hard.
This is the part of her story that always just blows my mind. She's at Harvard, one of the most prestigious institutions in the world. But you look at the class photos from that era, and it's just a sea of men in suits.
It was a class of about 500 men and 9 women.
9. That's not even 2%. It's basically a rounding error. And the dean, Dean Erwin Griswold. The story about him is legendary.
It is. The story gets told a lot, but we need to analyze the psychology of it. Dean Griswold invites the 9 women to dinner at his house, so they are sitting there, probably terrified, trying their best to fit in, and he goes around the table and asks each of them to their faces, "Why are you at Harvard Law School taking the place of a man?"
It's just breathtaking, isn't it? The sheer audacity.
The assumption being that a man would use the degree to support a family, and these women were just indulging a hobby, looking for a husband.
Taking up a valuable spot that a man deserved. So how did she respond to that?
She played the game. She gave a polite, demure answer. She said something along the lines of wanting to understand her husband's work better so she could be a sympathetic and supportive wife.
That is strategic. She didn't let him see he'd gotten to her.
It was survival, but internally. You have to imagine that moment just fueled the fire. She realized that no matter how smart she was, no matter how hard she worked, to the institution, she was an interloper.
And speaking of fire, her workload at Harvard it was superhuman. We hear about hustle culture today, but this is on a whole other level.
It really was. In their second year of law school, Marty was diagnosed with testicular cancer, and in the 1950s, that was often a death sentence. The treatment was massive, debilitating radiation. He was incredibly sick.
So Ruth just steps up.
She doesn't just step up, she takes over. She attends her own classes, she attends his classes, she takes notes for both of them.
Both sets of notes.
Then she comes home, types up his papers from his dictation because he's too weak to type himself. She takes care of their infant daughter, Justin. She prepares his meals, and this is the part that's just astounding. She does all of this while making the Harvard Law Review.
That is the part that feels like a superhero origin story. It just establishes this pattern that we see throughout her life. When things fall apart, Ruth works.
Work was her sanctuary. It was how she coped with chaos and grief. It was the one thing she could control. Marty eventually recovered, thankfully, graduated, and got a job at a big firm in New York.
So Ruth transferred to Columbia Law School for her final year to be with him.
And she graduated from Columbia tied for first in her class.
Okay, so let's look at the resume at this point. Top of the class at Columbia, law review at Harvard, glowing recommendations from her professors. In a pure meritocracy, This person has their pick of any job in the country.
In a meritocracy, yes. In 1960 New York City, she was unemployable.
How is that even possible? What was the reasoning?
She had, as she later put it, 3 strikes against her. She was a woman, she was Jewish, and perhaps most damning of all to employers at the time, she was a mother.
Why was the mother part the worst of the 3?
Because the assumption was that a mother would be distracted. She would need to leave early if the kid was sick. She wouldn't be committed to the firm in the way a man would. They thought her attention would always be divided.
So she just got rejected everywhere.
Everywhere. She applied to virtually every top firm in New York and got nothing. Not a single offer. She applied for a Supreme Court clerkship with Justice Felix Frankfurter, who was a progressive hero, by the way. He rejected her explicitly because of her gender. He asked her professors if she wore skirts. He told them he wasn't ready to hire a woman because he used, and I'm quoting here, salty language in his chambers, and he thought a woman's presence would inhibit him.
Unbelievable. That has to be just devastating, to do everything right, to be the absolute best, and be told you simply are the wrong shape for this role.
It required muscle, as she put it, to break the door down. Her mentor at Columbia, a professor named Gerald Gunther, basically had to strong-arm a district judge, Judge Edmund Palmieri.
What do you mean strong arm?
Gunther told him, if you don't hire her, I'm never sending you a clerk again. And if she fails, she doesn't work out, I will personally provide you with a replacement.
Wow, that is high stakes. That is putting your entire reputation on the line for your student.
It worked. She got the clerkship and she excelled, of course. But even later, when she moved into academia at Rutgers Law School in 1963, the discrimination was just blatant. She found out she was being paid significantly less than her male colleagues.
And the reason they gave her.
The dean told her, Ruth, your husband has a very good job. You don't need the money.
Oh my God.
The assumption was that women only worked for pin money, extra cash or luxuries, not for a living or a career.
It's infuriating.
Yeah.
But all of this, all these slights and rejections, they're building the foundation for the next phase of her life.
Yeah.
She's seen the system from the inside. She's felt the doors slam in her face. But before she starts tearing down those doors in America, she takes a little detour to Sweden. That seems random.
Yes, and this is a detail that often gets left out of the biopics, but it is absolutely crucial. In the early 60s, she was asked to co-author a book on Swedish civil procedure. She had to learn Swedish, and she spent time there observing their courts and their society.
And what did she see there that was so different?
It was a revelation. She saw a society where women made up 20 to 25% of the law students. She saw a female judge who was 8 months pregnant presiding over a trial, and nobody batted an eye. It wasn't a big deal.
It was just normal?
It was normal, and that showed her that the American status quo, where women were expected to be domestic appendages, wasn't natural, it wasn't inevitable, it wasn't biological destiny. It was a choice, a series of policy choices that could be unchosen.
So she comes back to the States, armed with this powerful new perspective, and she co-founds the ACLU Women's Rights Project in 1972. And this is where we really get to her strategy. She didn't just walk into the Supreme Court and say, hey, gender equality now, please.
No. And this is where the notorious image can be a little misleading. She wasn't a radical revolutionary in her methods. She was a conservative, and I mean that with a small c strategist. She used incrementalism.
You called it unraveling a sweater before?
Exactly. She didn't try to burn the whole sweater down in one go. She picked at the loose threads. She targeted very specific statutes that seemed minor on the surface, but which upheld the entire legal structure of gender discrimination.
And her genius was in her choice of plaintiffs.
Yes.
Yeah.
The choice of who would be the face of the case, it was brilliant.
She represented men.
Often, yes.
Huh.
It was a brilliant tactical move. You have to remember the Supreme Court at this time was 9 men, mostly elderly men. They didn't really believe gender discrimination was a serious constitutional problem. They saw it as, the natural order of things.
Civilry, even.
Right, protecting women. So she needed to show them that these stereotypes didn't just hurt women, they put men in a cage too.
Let's talk about a specific case. Weinberger v. Weisenfeld in 1975. This is the classic example in the research stack.
It is. So Stephen Weisenfeld was a widower. His wife, Paula, who was a teacher, died in childbirth. He wanted to work part-time and stay home to raise his infant son, the exact thing society told women they should do.
So he applied for Social Security survivor benefits to help him do that.
Exactly. But the law at the time said those benefits were only for widows, not widowers.
What was the government's logic there?
The government's logic was, men are breadwinners. If a man dies, his family is left destitute. If a woman dies, the man can still earn, so he doesn't need the government's help. It was based on this rigid 1950s view of the family.
So Ginsburg takes this case, and how does she frame the argument?
She argued that this law was a double discrimination. It hurt two people at once.
Okay, walk us through the two sides of that coin.
First, it discriminated against the deceased wife, Paula. She paid the same Social Security taxes out of her paycheck as a man did, but her contributions netted her family less protection. Her labor, her earnings, were legally devalued.
So it discriminated against the woman as an earner.
Precisely. And second, it discriminated against Stephen, the surviving father, by denying him the opportunity to be a primary parent solely because of his sex. The law basically said, you're a man, go back to work, you can't be a caregiver.
So it framed these traditional gender roles as a cage for everyone, not just for women.
Exactly. And she won that case unanimously, 9-0. It was a huge victory that proved the government couldn't rely on these broad, romantic generalizations about sex.
Speaking of the word sex, there's a funny story about that, isn't there? She stopped using it in her legal briefs.
She did. Her secretary at Columbia, a woman named Flo Kennedy, actually suggested it. She said, Ruth, every time you say the word sex to these male judges, they aren't thinking about the 14th Amendment. They're thinking about, well, you know.
Yeah, giggling like schoolboys.
It's distracting, the secretary said. So she suggested using the word gender instead. It sounds more grammatical, less biological, more academic. And it stuck. It was a small change, but a very savvy one.
That is such a practical, brilliant adjustment. Okay, another big one from this era. Craig v. Boren in 1976. This is the beer case.
The beer case, right. This was about a very strange Oklahoma law that let women buy low-alcohol beer, 3.2% beer, at age 18, but men had to wait until they were 21.
What was the justification for that? Because young men are reckless and drive drunk.
That was the state's entire argument. They had statistics that showed a tiny fraction more men between 18 and 20 were arrested for drunk driving than women. But Ginsburg, who filed an amicus, or friend of the court, brief challenged this. And the result was huge for constitutional law. The court established intermediate scrutiny.
Okay, let's break that down for us. We need to get a little technical here because this is really her legacy as a lawyer.
Right.
What is intermediate scrutiny?
Okay, so in constitutional law, there are different tiers of review the court uses to look at laws. At the bottom, you have rational basis. The government just needs a rational reason to pass a law. Most laws like traffic rules, tax codes, they just need to be rational. It's a very easy bar to clear.
And at the other end?
At the very top, you have strict scrutiny. This is used for laws that discriminate based on race or religion. To pass this test, the government needs a compelling state interest, and the law must be narrowly tailored. It is incredibly hard for a law to survive strict scrutiny.
And where was gender on that spectrum before Ginsburg?
It was at the bottom, rational basis. As long as the state had some reason, any reason at all, they could pass laws that treated men and women differently. Ginsburg's goal was to get gender treated like race, to get it up to strict scrutiny.
But she didn't quite get that.
She didn't. But in Craig v. Boren, the court created a brand new middle tier just for gender, intermediate scrutiny.
Which means what? Exactly. What's the test?
It means that for a law that discriminates based on gender to be constitutional, the state must have an exceedingly persuasive justification. It's not as tough as compelling, but it's a whole lot tougher than rational. It raised the bar massively.
So thousands of state and federal laws that were based on old stereotypes?
Suddenly became unconstitutional overnight. It was a sea change.
So she didn't get gender treated exactly like race, but she moved the needle in a huge, huge way.
She did. During this era at the ACLU, she argued 6 cases before the Supreme Court, and she won 5 of them. Her friend and later colleague, Justice Scalia, called her the Thurgood Marshall of women's rights.
And that's not hyperbole.
Not at all. Thurgood Marshall strategically dismantled legal segregation as a lawyer before he ever became a justice. Ginsburg, in the exact same way, strategically dismantled legal gender discrimination as a lawyer before she ever became a justice.
So let's fast forward. In 1980, President Jimmy Carter appoints her to the D.C. Circuit Court of Appeals, which is often seen as a stepping stone to the Supreme Court.
Right. It's the second most powerful court in the country.
And then in 1993, President Bill Clinton nominates her to the Supreme Court to replace Justice Byron White.
Now, looking back at the confirmation hearings for her, it's really interesting. She was confirmed 96-3.
96-3. That is a margin you just do not see today. It's unthinkable.
It is, and at the time she was viewed as a moderate, a consensus builder. She was good friends with conservatives on the D.C. circuit like Antonin Scalia and Robert Bork. Clinton wanted someone who was eminently qualified but also confirmable, and she fit the bill perfectly.
But she did set a very important precedent during those hearings, didn't she? The Ginsburg rule.
Yes. She refused to answer any questions about how she would vote on specific issues that might come before the court, like abortion or affirmative action.
And her reasoning.
She said she would give no hints, no forecasts, no previews. She argued that to do so would compromise her judicial independence and show that she had a prejudged opinion. Ironically, that precedent has been used by conservative nominees ever since to avoid answering tough questions about things like Roe v. Wade.
So she gets on the court. She's the second woman ever after Sandra Day O'Connor. And for a while, she is that moderate consensus builder people expected. But then comes 1996 and United States v. Virginia, the VMI case.
This is her masterpiece as a majority opinion writer. The Virginia Military Institute was a prestigious, state-funded military college that had only ever admitted men.
And their argument was that their special training method wouldn't work with women.
Exactly. They called it their adversative method, which was basically brutal hazing, zero privacy, intense physical discipline. They claimed that the presence of women would destroy this unique culture.
So as a compromise, they offered to create a separate school for women, right? The Virginia Women's Institute for Leadership.
They did. A classic separate but equal argument. And Ginsburg, writing for the 7-1 majority of the court, just took it apart, piece by piece.
How so?
She looked at the proposed women's school and said, this is not equal. It didn't have the same prestige, the same endowment, the same powerful alumni network, the same resources, or the same rigorous military curriculum. It was a pale imitation.
So she applied that intermediate scrutiny standard she'd helped create.
She did. She said the state's justification was not exceedingly persuasive. It was based on generalizations about women, not on the capabilities of individual women. She wrote that generalizations about the way women are, estimates of what is appropriate for most women, no longer justify denying opportunity to women whose talent and capacity place them outside the average description.
Women seeking and fit for a VMI education cannot be denied it. That line stuck with me.
Exactly. It was the culmination of her life's work as an advocate. It cemented the idea that the law must look at the individual, not the stereotype.
So she's writing these powerful majority opinions. But then, over the next decade, the court starts to change around her.
It shifts significantly. In 2006, Sandra Day O'Connor, who was often the swing vote, retires. She's replaced by the much more conservative Samuel Alito.
So suddenly, for a few years, R.B.G. is the only woman on the bench.
She is. And she finds herself in the minority more and more often. The court's conservative bloc solidifies.
And this is when the great dissenter is born. This is when the speckled collar comes out.
The dissenting collar. She actually had a specific black collar with gold embroidery and rhinestones that she would wear when she was reading a dissent from the bench. It was a visual signal to the courtroom and the press. I disagree, and I'm going to tell you why.
One of the most famous and impactful of those dissents was Ledbetter v. Goodyear in 2007. This case just makes my blood boil a little bit. Lily Ledbetter worked at a Goodyear tire plant for years.
Almost 20 years.
And she was getting paid significantly less than her male colleagues who were doing the exact same job. But she didn't know it.
Right, because of pay secrecy. It was against company policy to discuss salaries. She only found out years later, right before she retired, because someone left an anonymous note in her mailbox.
So she sued for pay discrimination.
She did. But the Supreme Court majority, in a 5-4 decision written by Justice Alito, said she was too late. The law said you have to file a claim within 180 days of the discriminatory act. They interpreted that to mean 180 days from the first bad paycheck she received nearly 2 decades earlier.
Even if she had no possible way of knowing.
Even if she couldn't have known. Ginsburg's dissent was scathing. She read it aloud from the bench, which is a rare and powerful move. She basically said the majority was completely out of touch with the reality of the workplace.
What's her core argument?
She pointed out that pay discrimination happens in secret. It's not a one-time event like being fired. It's a series of small, hidden injuries. You can't sue for something you don't know is happening. She said the court's interpretation ignores the reality of wage discrimination.
And she didn't just complain. She actually called for action.
She did. She ended her dissent by explicitly inviting Congress to fix the court's error. She said, the ball is in Congress's court. And it worked.
It did.
When Barack Obama took office, the very first bill he signed into law was the Lilly Ledbetter Fair Pay Act of 2009, which effectively overturned the court's decision and said the 180-day clock resets with every new discriminatory paycheck.
That is a real-world impact.
It is. It shows that a dissent isn't just shouting into the void, it's writing to the future. It's providing a roadmap for the legislature to correct what the dissenter sees as the court's mistakes.
Another really big dissent was Shelby County v. Holder in 2013. This was about the Voting Rights Act of 1965.
One of the landmark pieces of civil rights legislation. The court, in a 5-4 decision, struck down the heart of it, the pre-clearance requirement.
And what was that?
It was a formula that required states and counties with a history of racial discrimination in voting to get approval from the federal government before they could change their voting laws.
It was a preventative measure.
Exactly. And the majority, led by Chief Justice Roberts, argued that the country had changed, that racism wasn't the pervasive issue it used to be, and so this extraordinary federal oversight was no longer needed.
And Ginsburg had a perfect metaphor for that logic.
She did. It's one of her most famous lines. She said, throwing out the pre-clearance provision because it had been working to stop discrimination is like throwing away your umbrella in a rainstorm because you are not getting wet.
That line is just so good. It's so clear and powerful.
It cuts through all the legalese. And sadly, given the wave of new voting restrictions that passed in many of those same states immediately after the decision, many would argue she was prophetic.
Now, we've painted a pretty clear picture of a liberal hero. But the deep dive is about the whole picture. And the source material shows that R.B.G. wasn't always marching in lockstep with the modern progressive movement. There's a lot of nuance here.
Absolutely. And there's no better example of that than Roe v. Wade.
Yeah, this surprises people. She was pro-choice, obviously. But she had some serious critiques of the Roe decision itself.
She did. She thought the legal reasoning was shaky. Roe was built on a right to privacy, which the court found in the Constitution. It focused on the doctor-patient relationship. Ginsburg believed it should have been built on the 14th Amendment's guarantee of equal protection.
Her argument was that it's a gender equality issue.
Exactly. That laws restricting abortion access impose a massive burden on women that is not imposed on men, and that this denies women full and equal citizenship. She thought an equality argument would have been a much stronger, more durable foundation.
And she also thought the court moved too fast. Too far.
She did. This goes back to her incrementalist streak. She believed that in 1973, there was a democratic movement happening in the states to liberalize abortion laws. New York, Hawaii, others were already moving in that direction. She felt the court stepped in with a sweeping nationwide ruling that halted that political process in its tracks.
And that created a backlash.
A massive backlash. It galvanized the anti-abortion movement and made the issue a central front in the culture wars. She wondered if a more gradual judicial approach, one that maybe just struck down the most extreme anti-abortion law in Texas, might have built a more durable public consensus over time.
That is that same incrementalist thinking we saw from her ACLU days. She preferred measured motions.
It's who she was. She was an institutionalist at heart.
What about her views on criminal justice?
It was a mixed bag. On the Fourth Amendment, which protects against unreasonable search and seizure, she could be a very strong defender of individual rights. There's the famous strip search case, Safford Unified School District v. Reading in 2009.
This is the one where a 13-year-old girl, an honor roll student, was strip searched by school officials because another student said she might have ibuprofen.
Ibuprofen, not heroin, over-the-counter pain medication. During oral arguments, some of the male justices they were making light of it, suggesting it wasn't a big deal, that kids change for gym class all the time.
And Ginsburg was not having.
She was furious. She later told an interviewer, "They have never been a 13-year-old girl." She understood the profound humiliation and trauma of that experience, and her perspective was crucial. The court ultimately ruled 8-1 that the search was unconstitutional.
But then there are areas where her record is more complicated for liberals, especially on Native American law.
Yes. This is a prime example of her complexity. In 2005, she wrote the majority opinion in City of Sherrill v. Oneida Indian Nation.
This one is it's a very difficult ruling for indigenous rights advocates.
It is. The Oneida Nation had, over time, bought back land on the open market that was historically part of their reservation. They argued that because it was their ancestral land, it should be sovereign tribal land again, exempt from local taxes.
And Ginsburg wrote the opinion saying no.
She did. She used concepts like the doctrine of discovery and the legal principle of laches, which basically means you waited too long. She argued that the area had been governed by New York for so long, and so many non-Indians now live there, that returning it to tribal sovereignty would be too disruptive.
Too disruptive, a very pragmatic argument.
It was, but it was seen by many as relying on colonial legal doctrines to deny justice. However, to show the complexity, fast forward to near the end of her life in 2020. She joined the majority in McGirt v. Oklahoma, a landmark decision that affirmed that a huge portion of eastern Oklahoma was, in fact, still Native American reservation land.
So her views on this clearly evolved, or at least the application of her principles depended heavily on the specific facts of the case.
It just goes to show you can't put these justices in a simple ideological box. They contain multitudes.
No, you can't. Okay, let's pivot from the law to the person behind the robes, because you can't really talk about Ruth without talking about Marty.
Their marriage was truly modern before its time. We mentioned he was the outgoing one, the social butterfly. He was also the chef.
Ruth couldn't cook.
By all accounts, she was a terrible cook. Their children basically staged an intervention and banned her from the kitchen. Marty took over the cooking completely and became a renowned amateur chef.
And he was her biggest cheerleader professionally.
Our absolute biggest. In the 1990s, when there was a vacancy on the Supreme Court, he was the one campaigning for her to get the nomination. He was calling in favors, working his network of lawyer and politician friends. He knew she wouldn't promote herself, so he did it for her.
A true partnership.
A 50-50 partnership in an era when that was almost unheard of. He passed away from cancer in 2010.
And in true R.B.G. fashion, she was back on the bench the very next day.
She was. She said work was what he would have wanted, and work was how she coped. It was her sanctuary.
And then there's the other man in her life, Justice Antonin Scalia, the ultimate odd couple.
The conservative arch-rival. They disagreed profoundly on almost every major legal question. But they were the best of friends.
They vacationed together, right?
Well, they did. They spent New Year's Eve together every year. There are famous pictures of them riding an elephant together in India.
And the opera.
They were both absolute opera fanatics. They even appeared as extras in productions together. There's a whole comedic opera written about their friendship called Scalia Ginsburg.
What does that friendship tell us? In today's polarized world, it seems impossible.
It tells us that they valued intellect and collegiality over ideology. They could fight tooth and nail about the Constitution in the morning and share a bottle of wine and a good meal in the evening. Scalia once said, "I attack ideas, I don't attack people." Ruth appreciated that. She famously said that Scalia made her opinions better because he would read her drafts and find all the weak spots in her arguments.
Iron sharpens iron.
Exactly. It's a lesson in civility that feels very distant right now.
Now, we also have to talk about her physical resilience. Because looking at her, especially in those later years, she looked so frail. But she was.
She was a tank, an absolute tank.
She survived 5 different bouts of cancer.
Colon cancer in 1999, then pancreatic in 2009. She had a stent put in her heart. She had cancerous nodules removed from her lung in 2018, and then the pancreatic cancer came back.
And through it all, she rarely missed oral arguments. She'd schedule chemotherapy for Fridays so she could recover over the weekend, be back on the bench Monday morning.
It was an unbelievable display of will.
And the push-ups. We have to mention the workouts.
The push-ups. After her first cancer bout, she hired a personal trainer, Bryant Johnson, a former Army Special Forces guy. She started training with him twice a week. At age 80, she could do 20 push-ups.
She can barely do 20 push-ups now.
Most people can't. It became part of her legend. The R.B.G. workout became a book, a phenomenon. It was this act of reclaiming physical strength when her body was under assault. She wasn't just a brain in a jar. She was physically fighting to stay in the game.
And all of that, the dissents, the workouts, the resilience, it all feeds into the Notorious R.B.G. persona. How did she feel about all that? The T-shirts, the tattoos, the memes?
She loved it. She completely owned it. She had a supply of the T-shirts in her chambers that she would give out as gifts. She thought it was hilarious that a law student blogger had connected her, this tiny, serious octogenarian judge, to the rapper Notorious B.I.G.
It bridged a gap, didn't it? It made the Supreme Court feel relevant and, dare I say, cool to a generation that might not have paid attention otherwise.
It absolutely did. But it also created a complication, because when you become an icon, a superhero, people expect you to be invincible. And that leads us to the final and very difficult chapter of her story.
The retirement question.
This is the elephant in the room of her legacy. During the Obama years, specifically around 2013 and 2014, there was a lot of pressure from liberal commentators and legal scholars for her to retire.
And the logic was what?
The logic was, she was in her early 80s, she'd had cancer twice already, and the Democrats held both the White House and the Senate. It was the perfect window for President Obama to appoint a young, liberal successor who could serve for decades.
And she refused.
She did. She famously invited Obama to lunch at the court, but she did not step down. Her argument essentially was, who would you prefer? She looked at the political climate, the rise of the filibuster, the intense gridlock, and she genuinely didn't believe Obama could get a true progressive confirmed. She thought the nominee would have to be a compromise candidate.
She thought she was still the best person for the job.
She did, and she wanted to emulate justices like Brandeis and Stevens, who served until they were very old, as long as she felt she was mentally sharp.
And by all accounts, she was sharp until the very end.
She was, but she was making a gamble. A huge gamble on the 2016 election. She expected Hillary Clinton to win and to name her successor.
It did not happen.
No, Donald Trump won. The Republicans held the Senate, and Ruth held on. She fought through more cancer. She fought through broken ribs from a fall. But on September 18th, 2020, she died.
On the evening of Rosh Hashanah, the Jewish New Year.
Yes. There is a Jewish teaching that the most righteous people die at the very end of the year, on Rosh Hashanah, because they are needed until the very last moment. It felt deeply poetic to her admirers.
And she was honored for that service. She was the first woman and the first Jew to lie in state at the U.S. Capitol.
A historic honor. But the political aftermath was immediate and brutal. Her dying wish, which she dictated to her granddaughter, was that she not be replaced until a new president is installed.
But we were just weeks away from the 2020 election.
And that wish was not honored. Amy Coney Barrett was nominated and confirmed in record time just days before the election, cementing a 6-3 conservative supermajority on the court.
It was the exact scenario that Ginsburg and her supporters had feared and tried to prevent.
It was. And by staying on the bench, she inadvertently allowed it to happen under a Republican administration. It's a tragic irony in a career that was so defined by foresight and strategic thinking.
It is. And it certainly complicates her legacy. But as you say, it doesn't erase it.
No, it doesn't.
So let's wrap this all up. When we look at this entire stack of research, what is the ultimate takeaway from the life and law of Ruth Bader Ginsburg?
The takeaway, I think, is that she changed the world for American women and for American men. And she didn't do it by waving a magic wand or leading a protest in the streets. She did it by sitting in a library, reading thousands of pages of case law, by finding the perfect plaintiffs, and by knitting together a legal argument, stitch by careful stitch, over decades.
From the woman who couldn't get a job to the justice who redefined the very meaning of equality under the law.
Precisely. She proved that the law is not static. It can be moved. But you have to be willing to do the slow, patient, meticulous work.
So here's the thought I want to leave all of you with today. R.B.G. was the master of the long game. She believed in incremental change, in consensus, in measured motions. But in her final years, she became an icon of resistance in a polarized, fast-paced, mean-driven world.
The question is her style of patient, strategic legal architecture still possible? Or has the era of the consensus builder truly passed? In a world that seems to demand instant results and radical shifts, can an incrementalist still change the world?
Something to think about. Thanks for diving in with us.
Thank you.